What's going on, everyone? Welcome to the BNB Formula podcast. In today's episode, we have Jeff Hampton from STR Law Guys. In this episode, we talk about how to protect a short-term rental that you're renting, and then also we go very, very deep into asset protection. So I hope everyone enjoys. So Jeff, we met at STR WealthCon in Nashville this year, and your company. I've met other attorneys that have helped with asset protection and say with just in the short-term rentals in general, but never really anyone that specialized in it to the extent that you were talking about on it. And it was around a time, like I own 14 properties, and that was when I first met you was and saw you speak from stage. That was one of the first times that I had actually I knew a little bit about asset protection, but nothing to the level that you were teaching. So for everyone that's listening and watching, if you want to just give everyone your story and then just sort of what you're working on now and just how asset protection for rental arbitrage and everything, we're going to share some slides here in a second, but just how all that works and how that's all been evolving in the last, say, like 5 to 7 years with just the explosion of short-term rentals.
Yeah, absolutely. So I have a little bit of a unique perspective on it because in my past, one of my law firms that I was actively involved in for a number of years, I'm not as involved in it as much anymore, but I was a personal injury attorney so I would bring lawsuits against commercial property owners and short-term rental owners.
Awesome.
So yeah, for premises liability events. So
Yeah.
a big part of what I would do is bring these lawsuits for slip and falls and swimming pool accidents and things like that. And so that was kind of my main thing for a while. But then, of course, I started investing in short-term rentals. So I became like everybody else here that's, you're looking to own an asset, you're trying to create some passive income and make some, create some long-term wealth here. And as I did that, obviously I had a fairly good perspective on what was working in court. And that led me towards kind of, as I was in some of these groups of other investors, I would start to share, well, be careful. I know you hear about this, but be aware this is what actually happens when you go into court. And I'd have a lot of the investors go, wait a minute, you're going to need to break this down for me. Why are you not helping people do this? Because you're fairly aware of what's going on. That's what kind of planted the seeds for the origins of STR Law Guys. And then ultimately us being able to take it, not just from an asset protection perspective, but an investor's perspective. I mean, everything needs to be taken into consideration, both the tax side of things, the lending. You want to make sure for every action you take, you can get a lawyer that's going to come and tell you, you need to do all of these things to protect your assets, but how does it interplay with those other aspects of things in the future if you're planning to continue to grow your portfolio? So that was the seeds that led towards Stephen Tobin, and my law partner, him and I putting together STR Law Guys. And now on that end, we try to be very specialized for folks in the STR space because, I'm a big believer in layered asset protection, which means you need to have a short-term rental lease agreement to help shift some of the liability in terms of liability waivers back over onto the guest. We also have insurance review. You got to have the right kind of insurance. And I'm going to talk a little bit about that in a little bit more detail here in a minute. But then you start talking about LLCs and holding company strategies. And I know a lot of your listeners right now are a lot of them are focused on things like co-hosting and arbitrage. And I'll cover that here in a second. When we share some of these visuals, I'm going to show you visually how that would play in. But to give you since you asked the question, I'm going to give you a quick answer to that piece. Co-hosting, pretty simple. Okay. From a co-hosting perspective, there's two things you need. You need an LLC that is with a separate bank account that's tied together on it, that you don't commingle with other activity. And you need that set up for that purpose. And then you need a co-host agreement. Now, what I mean by that is, why do you need a co-host agreement? Most people know about an LLC, but the co-host agreement is the agreement that you have with the owner or the landlord, however you're setting this up here, where you want to make sure when you're dealing with that owner, they have the responsibility and under the law, what's known as the duty of care to maintain the property. And your primary risk is if someone gets hurt, who are they going to sue? They're going to sue you, and they're going to, because you're helping them manage the property and the owner. And then the owner could turn around and sue you by claiming you weren't negligent. You were negligent by how you were maintaining it. That's why that lease or that co-host agreement sets up the rules for the relationship. And you can tell them right out of the gate, here's what you do. Set up your LLC, sign the co-host agreement in the name of your LLC, and make sure that co-host agreement establishes that maintenance and that duty of care is on the owner and not on you, which is a big component of that for co-hosting. Now for arbitrage, go ahead.
I was going to say, especially with all the different states and everything, with all the different regulations, like I can see that being an issue for individual. We have we call it the BNB Formula toolkit, but we have like a bare bones one. But we always say like consult an attorney before you actually use this. I mean, some of our students, I mean, I'm guilty of it too. I've taken that agreement and just used it, but nothing's ever came from it. But we do have some students that ask like, does an attorney need to review this? And we always recommend, obviously, like, yeah, we do recommend an attorney review this both in your state, and just every single situation is so different. So
yeah, it sure is. And that's a really good question too, is we're going to look at that here in a second, where we talk about every state has different rules and regulations. And with co-hosting, some states require you to be licensed if they believe you're property managing. And that can come up with issues where, what's the difference between co-hosting and property management, right?
Yeah.
And so
I know North Carolina's like that. Yeah, like yes, I know. I mean, there's a lot of people that do it without a license and haven't been caught, but I know in North Carolina you technically need to have a real estate license to manage, instead of co-host. Yeah.
That's right. And so when you look at some of the regulations related to that, a lot of these states start defining a property manager as someone who's collecting all the money and then kind of distributing it. And so one way that some, just strategically for your co-hosts out there to know this, one way to do that is to invoice the owner for everything, have a co-host agreement set up, invoice them for everything. It's a little bit more of an arm's length transaction. I know it's a pain, but it actually helps in some states, helps separate you from that property management argument. And now you're acting in good faith. Because here's the thing, a lot of these regulations that are written in these states, they haven't contemplated co-hosting, because they don't even know what it is, right?
Yeah, so they were made before Airbnb existed. Like
100%, that's exactly right. And so what we want to be able to do when something's not settled in stone in terms of regulations is to be acting in good faith as best we can, right?
Yeah.
So
cool. Yeah. So if you want, let's hop. Instead of talking about this, what we realized was the best way to do it. And I've seen you give this presentation before. This is the first time I saw it. I was mind blown. So what we're going to do is we're going to hop over to your screen, and Jeff's going to sort of just go through with some visuals on exactly what he's talking about here with asset protection in both purchasing and with rental arbitrage, co-hosting, BNB Formula, whatever you want to call it. So
absolutely. Yeah. So I'm going to go through a lot of this content fairly quickly, but from the standpoint of giving you a baseline foundation of understanding what this is. Okay. So I do think it's somewhat important to understand that essentially asset protection, we are trying to reduce the likelihood of an attacking attorney, whether it's an unscrupulous attorney or whether it's a creditor trying to come after you. And really, you're trying to protect two things. You're trying to protect the asset itself, but then you're trying to protect your personal assets from being obtained if something happens and you end up, turning out in a bad way in that lawsuit. We look at short-term rentals, and just short-term rental activity generally is seen as higher risk. You have more guests coming in and out of these properties. If you're an owner, it's high risk because of that. You have just more volume. There's more people that are there. And so as just pure mathematical computation here, statistically, you have a higher probability of running into that as an issue. So that's what we're looking at. I mentioned earlier that I'm a former personal injury lawyer. You want to be careful about some of what they do here. Now, I have to give this obligatory disclaimer. I do it with everybody. I am a lawyer, but I'm not your lawyer. So this is educational information that I want to provide you guys. And it can be very specific depending on your situation. So I want to just give that out of the gate. So let me give you a quick rundown. We start talking about layers of protection. And by the way, I'm going to customize this for co-hosting and stuff like that too. We talk about number one, I talked about the lease agreement, which we discussed a few minutes ago. But number two is the insurance. Now I'm going to tell you, if you're a co-host, you need errors and omissions insurance. It's a business policy. You can easily go get that. You can go get that set up. And even though you don't own assets, you want to make sure and have an E&O policy that protects you in case there's an argument that you were somehow negligent or missed something. That's a piece there. If you're an owner, we're going to talk about the fact how important it is to have commercial insurance here in just a minute. And then we talk about single purpose LLCs. We're going to talk a little bit about the limited partnership structure. We'll talk a few moments about a land trust, and then we'll put some of it together here. So number one, insurance. And this is the part I want to remind everybody very quickly. I'm going to kind of boil it down to three main points. But number one, I want to remind you all residential policies for short-term rentals are deficient. If you go get a second home residential policy for a short-term rental, I'm going to warn you right now, go to page 60 to 80 on your policy. If you go to page 60 to 80 range, you're going to see an exclusion section. On that exclusion section, it's going to say business or commercial activity. I'm going to tell you, every state has ruled that short-term rental activity is business or commercial activity. You're making money off of it, right?
100%.
So I've seen this happen over and over again where someone gets a second home residential policy. And I have a story about this. Lady fell staying in North Carolina at a really nice short-term rental. It was a loose handrail. She fell back, hit her head on the actual sharp part of the stair. She was in ICU. It was a very serious injury, what led to a claim against the insurance. But guess what? Insurance denied the claim because it was a residential policy. This person's now hanging out in the wind with potential liability because they didn't have things set up properly. So it's really important that you don't just rely upon what an actual agent says. If you start talking to an insurance agent, don't just believe what they're telling you. So each is designed to exclude any risk associated with the other. And so when people tell me, yeah, but maybe my homeowner's policy covers it, very unlikely. So that's why you want to make sure and start looking at three main, and I say it says four here, but it's primarily three main essentials. Number one, it needs to be commercial in nature. So no exclusions when it comes to this. Number two, let's talk about premises liability coverage. What is premises liability? That protects you from someone getting injured. Okay. Generally speaking, I say $1 to $2 million in premises liability coverage under a commercial policy. A lot of people are sitting at that 300 to 500 range. You know how easy it is to eat that up if somebody gets hurt when you go to the hospital, if you're in there for a bit. So you start talking about how you want that to be $1 million to $2 million. The second thing you want to talk about is what we call the dwelling all risk coverage policy. That's important because there it's talking about, what if somebody burns down your place and you have to rebuild? What is it going to cost to rebuild relative to what you're insured for?
Right.
That's critical. A lot of people are insured for a rebuild price from 10 years ago or 5 years ago.
That was what I was going to say. Like we develop most of our properties, and I mean we recently went through that. Was most of our insurance policies on anything that we built prior to COVID had replacement costs, but then for 2016 pricing.
Yes.
Yeah. Which can be
and
30
so many
to 40%
people
higher now.
Absolutely, with inflation and supply chain issues, and now
furnishings. That's another thing that people don't remember. Like think about,
all of it. Yeah, I mean, you could be talking about. I mean, I even gave an example at the conference where I talked about someone who ends up having like a $250,000 gap. Right.
Yeah.
I mean, if you have that gap, you're sitting in the wind and you're in a bad spot. So it's important to make sure you stay on top of that piece of the policy. And then the final one I want to talk about is loss of income, which, people, if you have really a commercial policy, if you mention loss of income and they look at you like, we're not interested in helping you with that,
right.
you're in a little bit of a wrong place.
It's the wrong. Yeah.
That's right. Yeah. So you want to make sure that if something happens, you have to pull your asset off of Airbnb or VRBO, and you're not able to make money on that during that time frame, you're able to cover your carry costs and the loss of income that you have. So that's an important piece there. Okay, now, so we talk about insurance, and I talked about errors and omissions. That's real easy. You can go to a commercial insurance provider and say, I'm a business. And by the way, how do you prove that you're a business? You're running your co-hosting business out of an LLC, right? You're actually setting up an LLC with a separate segregated bank account. You're doing your business like you're supposed to. And then you get an errors and omissions policy that will help cover you in the event of some sort of issue that arises while you're co-hosting. So that piece is important. Now let's talk about LLCs, single purpose LLCs. LLC, we know, stands for a limited liability company. It's wonderful as an introductory piece, because what it does is separates, on a very basic level, it separates your ownership of an asset from your control of the asset. Once you move an asset into an LLC, you no longer own it. You control it, but you don't own it, which helps provide you the protection under the law, okay? Now, some people tell me, Jeff, can I do multiple businesses in one LLC? Or can I move multiple properties into one LLC? You can, but you shouldn't, okay? And the reason why, I just spoke to an investor earlier today. They had 4 properties in one LLC, Okay. Now think about this. If one bad thing happens at that one property, at one of those properties, but all four of them are owned in one LLC, the personal injury lawyer is going to sue the LLC, and everything in that LLC, all four properties, is frozen. And if you lose the lawsuit, there's a chance that the entire portfolio can be liquidated. So instead, what you do is you need to put one property into one LLC, segregate the property, isolate the risk. Okay. And when we talk about this as well, I'm going to talk about, because right now we're just primarily talking about LLCs and we're not getting into holding company strategies, but let's use this as a visual. Okay. So we start talking about a visual. Let's say this is you. And I didn't even get into exempt assets. Most of the time you can talk about your homestead and your retirement. It can be at least somewhat exempt. Okay. Florida and Texas have total homestead protection. Every other state can range between 20 to 300,000 in coverage, depending on what you have for protection there. But your retirement is almost always protected under the Employee Retirement Income Securities Act. To some extent, you have protection against bankruptcy or a lawsuit. So your risk is what? Your primary risk is all of your real estate assets. That's what everybody's trying to do here, is to create that wealth. So we use this example of a mountain cabin short-term rental in Tennessee and a beach house short-term rental in Florida. You would want them to be in their own individual LLCs. If your beach house is in Florida, put it in a Florida LLC. If your mountain cabin is in Tennessee, put it in a Tennessee LLC. Don't put them in the same LLC. Tie them off separately. Have a separate insurance policy for each, and that is the very minimum. Now, what if you're doing arbitrage? Let's talk about arbitrage for a second.
Yeah.
If you're doing arbitrage, it's a little different. Arbitrage is you're protecting primarily, it's known as privity of contract. You're trying to protect yourself in contracts. You don't own anything. So what you're doing is you would still want to set up an LLC that you do the same thing as we talk about with co-hosting, except arbitrage is a little different. You're just signing contracts. So ideally you would sign contracts not in your name, but in the name of your LLC. Okay. And in the process of signing contracts in the name of your LLC, you're preventing a breach of contract issue from getting to your personal assets. If the landlord sues you or someone else, an Airbnb guest, tries to go after you. Okay. Now I have some clients that have come to me and said, Jeff, look, the landlord won't let me sign my lease in my LLC, because they sometimes won't do that. Well, there's a way around that. Sign the lease with the landlord in your personal name, then sublease to your LLC. Okay. Sublease it to your LLC, and then your LLC can sublease out to every Airbnb guest. Okay. So by doing that, notice what you're doing. You still have some connection to the landlord, but you're putting some separation between you and all the guests that are coming from Airbnb as they're staying there. So there's two main things you need. You need an LLC, and you need a short-term rental lease agreement for all of your guests. So if you're doing arbitrage, it's really important that you have a lease agreement, a contract. I know a lot of people don't like this. They're like, yeah, I'd just rather rely upon the Airbnb rules. Well, be careful. I just want to warn you. Here's what happens if you actually get in a breach of contract. Or if you need to, what if you have to evict somebody, right? What if something comes up and they won't leave? Like that story of that lady that stayed in that place in
California.
California, right?
Yeah,
well,
yeah.
if you don't actually have a lease agreement, the first thing the judge is going to say is, let me see your agreement. What did y'all agree to? And they're not going to care what a third party, like Airbnb says. That's not going to be something that's going to affect you in a courtroom. So it's important to have a short-term rental lease agreement and have each owner that you sign with sign off in the name of your LLC. You're protecting yourself in a contract arrangement. Okay. Now I like to put 2 or 3 contracts in each LLC. Okay. Now you can create more LLCs if you want to in the states for which you're doing your arbitrage stuff, because most people will do, once they find a good market, they'll double down. They'll do a lot more arbitrage deals. And so you could just set those up in that same state LLCs, and you create a little bit of separation, 3 or 4 contracts per LLC. And that's really what you need for arbitrage. Okay. So that piece will cover you there. It's a little bit more on the simple side to get started when you start talking about arbitrage and co-hosting. All right. Now, let's talk about this for a second. Why not? Couple of myths to dispel. Some people say, well, Jeff, listen, why wouldn't I just stop right there? If I have a property and I move it into an LLC, why would I need to do anything else? Well, there's two things you don't have in overall most states. There's really only two or three state laws that provide you what I'm about to explain to you right now. Otherwise, most of the most popular short-term rental states to purchase short-term rentals, they don't provide you the protection that you need for a basic LLC. So there's two things. Let's use the example of Tennessee and Florida. Tennessee and Florida do not have what's called privacy and charging order protection. Okay. So what that means is when I say there's no privacy, let's go back to this. If I bring a lawsuit at your beach house in Florida, even if you move this property into an LLC, which it's illustrated right here, I'm going to go to the Florida Secretary of State and I'm going to ask who are the members. Okay. I'm going to find out that you are the member. And then the attorney is going to sue you personally, individually, because you're a member. They're going to bring you into the lawsuit and the LLC. And here's the thing. There are some negatives here. You've got to be careful. There's a term known as piercing the veil. It's a concept known as piercing the veil. If I can show that you failed to keep your annual meeting minutes, failed to set up a functional operating agreement, failed to follow the corporate formalities for your state, or here's the big one, commingled funds, because almost everybody will commingle some personal and business funds, then the attorney is going to do an asset search about what you own and bring you into the lawsuit. So that's one thing you don't have is privacy. The second thing you don't have is what's known as charging order protection. So let me illustrate this. If I bring a lawsuit against your property in Florida and I win, let's say it's the LLC, we go to court, we battle it out, and I were to be the attacking attorney and I won the lawsuit. I could go to the judge and say, Judge, I want to force a sale of this property so I can get paid. And the judge will say, approved, okay? Because I won. But we would prefer that not to happen, right? So what we do is we level up our protection. You say, well, I got to have some more protection than that. That's why I say to get an asset out of your personal name into an LLC, that's good. But better than that is to use a holding company strategy, okay? And let's talk about what that is now. Quick distinction, just so I can walk you through it. Now, remember what I said earlier. Very basic. You want to get the property out of your name into an LLC. But remember the problem we talked about it being in your personal name, or I mean, it being listing you as the member. Well, how do you avoid that? Well, now what you do is you set up an LLC for these properties, and now you list a LLC in a state that has preferential laws as the single member. Now, you can look at Wyoming, Delaware, Nevada, but I like Wyoming the best. And the reason why for this example, for kind of a small but growing portfolio, this example, the reason why I like this is because Wyoming has the oldest laws on the books related to LLCs, the most court precedent. It establishes that for LLCs as a holding company. Here's what you get now. You get privacy and charging order protection. If I were to bring a lawsuit against this same Florida beach house and I go to the Secretary of State, what are they going to tell me? They're going to say, go to Wyoming. That's right. You got to go to Wyoming. So when I go to Wyoming, what are they going to say? Hey, we have certain state laws here for privacy. I can't tell you who the members are. Okay. And then number two, any good personal injury lawyer is going to immediately know, oh man, they've got charging order protection. So now how do personal injury lawyers get paid? And this is important for your listeners to know this. They get paid on a contingency fee basis. That means they get paid a percentage of the recovery. That also means they have to pay for all the expenses of the lawsuit out of their own pocket initially. So now if I look at your assets and I don't know who you are, and I can't make you sell, you become very unattractive to me.
Right.
So that's why good asset protection always pushes lawyers down to good insurance every time. So if you have good insurance, then you're making it easy. You're pushing the easy button for the personal injury lawyer, because the personal injury lawyer doesn't want there to be any chance that they're not going to get a recovery. So you send them down to the insurance, and what you want to do is to avoid him going after you. Okay. So that's what this structure does here as an example of that. And so I kind of covered a lot of this as we went through it. It's wonderful for a small portfolio. The only negative, I will tell you this, the only negative to this, let me go back here. The only negative to this structure right here is that if you have a growing portfolio, let's say you get to a portfolio size 4 or 5 plus properties, right? You can end up, I've got a client with 89 properties. All right, let's talk about that for a second. What happens if one of them gets sued? If you have all 89 properties in a single Wyoming LLC holding company,
it can be more attractive to,
Well,
yeah.
that, and here's what happens. It's very difficult. Not only that, it can be very difficult to actually manage your portfolio, because if one of them gets sued, that's all owned by a Wyoming LLC holding company, everything freezes in that holding company. Okay. Now think about this. If I wanted to move the Mountain Cabin STR LLC in Tennessee out, but currently I'm under litigation in my Florida LLC, that would be labeled a fraudulent transfer. The courts would say, whoa, 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 why are you moving stuff out of this? You're trying to avoid the judgment. What are you trying to do here? They will heavily scrutinize you. So what that can end up doing is creating some cash flow management issues and some post-lawsuit paranoia. You can start saying, well, what if I need to take some money? Let's be frank. Some of our portfolio performs better than other parts. And sometimes we will take some of that money and we will use it to renovate other portions of our portfolio and do things like that. Well, now you have to be very careful doing that when you have a large portfolio and it's all owned in a Wyoming LLC holding company. So I warn people, that's the only negative. It's the only negative of this structure. That's when we move to part two. We talked about good, better, and best, right? So, and this is the part for any of your listeners that maybe have 4, 5 properties or more, right? You're starting to talk about significant holdings, a lot more that's at risk. I'm going to give you a quick key overview on this. All right, let's go down here and we're going to talk about the Arizona limited partnership structure. Now, what I'm going to do is, and I think you mentioned that I was okay to do this earlier, is I'm going to show you a visual. I'm going to show you an actual animation of this here in a second, but I'm kind of moving through this. What is an Arizona limited partnership? Best way I know how to describe this, limited partnerships are used a lot in real estate syndications. Okay. So I like Grant Cardone. So I use the example of Grant Cardone, right? Just kind of joking with Grant about Grant Cardone. So let's say Grant has a 500 unit apartment complex and he's out there saying, I want you guys to invest in it. Well, who is he? He's the general partner. He's the guy running the day to day. He's completely liable for everything that goes on. What if you and I invest in his fund? I have no idea what Grant Cardone is doing, but I hope to get money back, right? I hope to make money. I am a limited partner. I have no liability in the entire incident. So the way this works is Arizona allows you to use this in the capacity for real estate. And so in the process of doing that, we have an Arizona limited partnership. Who is going to be the general partner and who is going to be the limited partner? Here we use the example of, and this says asset protection trust, but really what we do is we use what's called a revocable living trust. We can use a trust in the place of the limited partner, and we can use a Wyoming LLC in the place of the general partner. I don't want to lose everybody here, but let me walk you through why we do this, okay? So let's say you've got a large portfolio. Think about this. Here's what happens in a lawsuit now. If I want to bring a lawsuit against the Beach House STR in Florida, it's in its Florida LLC, I go to the Florida Secretary of State. They inform me it's owned by an Arizona limited partnership. So I go to the Arizona Secretary of State. Under Arizona law, the limited partner, as this trust, is always private. I cannot see it. Okay, I cannot see the limited partner. Secondly, now that trust kills 2 birds with 1 stone. It allows you to not only have this in place for the limited partner, potentially for asset protection, but it also allows you to take care of your estate planning needs. You can appoint your trustee, your beneficiaries. It helps you avoid a will contest, probate court. It allows you to take care of that piece, and it's integrated into the structure. And then secondly, we set up, in this lawsuit, remember, we're still talking about a lawsuit, I can see the general partner. But if you use a Wyoming LLC in the place of the general partner, I can't see you. Okay. But the only thing I can see is the asset allocation. And what we do is we put together an asset allocation where we do 99.5% of the portfolio value goes into the limited partner trust, and 0.5% of the portfolio value goes into the general partner Wyoming LLC. Now, here's why this matters. Let me walk you through this. Okay. Bear with me. I'm going to stop sharing my screen and I'm going to share with you a different screen right quick. And I'll walk you through this so everybody can see this. So let's go back to where we are on this. So as we pull this up, let's take a look at same thing I just shared with you a second ago, just a different visual, right? You still have the Beach House STR in Florida. You've got a Mountain Cabin short-term rental in Tennessee. Now here, let's flip the script. Let's say this Mountain Cabin Tennessee is being sued. Remember what we said. We've got the Arizona Limited Partnership, a limited partner family trust that owns 99 to 99.5% of the entire portfolio. And you have a general partner, Wyoming LLC, that owns 0.5% to 1% of the portfolio. So let's say the lawsuit starts down here in the green where the mountain cabin short-term rental is. When I look at this, remember, I can't see the trust. I can see the general partner Wyoming LLC, but I can't see you. But I can see a very small amount of assets in that trust, in that Wyoming LLC. So here's what that does from a preventative nature. The attorney sees this. What do you think the odds of a Tennessee lawyer, personal injury lawyer, being licensed to practice litigation in Arizona?
Right.
Very small.
Very small.
Very small. So unless it's like some big law firm like Morgan & Morgan, nationwide law firm, very unlikely that's going to happen. So what will take place here is that attorney is going to have to go get co-counsel. If you go get co-counsel, what happens? Litigation costs go up, right? It's going to cost more money. But on top of that, you don't see very many assets because there's a small amount of asset allocation here for the general partner. So what happens is the attorney now has an ethical duty to go back to the client, the slip and fall client, right? The personal injury lawyer, and say, hey man, look, we can sue through all of this if you want to, but I'm going to warn you, I don't see a whole lot of assets. Secondly, we got to get another lawyer involved because I'm not licensed to practice over here in Arizona. And there's a chance that I'm going to make more money than you, which most people don't want that. They don't want their lawyer to make more than them. And secondly, there's a good chance you'll make way less than if you just took the insurance settlement. Okay. That avoids the vast majority of claims from ever extending into Arizona. But if it's a seriously bad accident or something terrible happens, here's where the Arizona piece is really protective. Under Arizona law, it says in the event of a crisis event, which a lawsuit has been labeled a crisis event, this limited partner trust may sever the relationship with the general partner Wyoming LLC as long as two things are in place. Number one, this limited partnership agreement must be drafted properly at the time to allow the limited partner trust to leave once you get sued. And number two, you got to do it before you get sued. This is the biggest question that people ask me. Look, you don't need asset protection until you need it, right? And then once you need it, it's too late. So right. This is a peacetime effort. It's not a wartime deal. You can't just throw this together after you've already been served with papers. But here's an illustration of what it looks like. If I were to bring the lawsuit against the Mountain Cabin Short-Term Rental LLC in Tennessee and extend this into Arizona, the law says that the limited partner trust can sever the relationship with the general partner Wyoming LLC. And now we have a red line of firewall of protection right here. And it can take all the other assets and leave the relationship. And the only area that's vulnerable now was the original property being sued and 0.5 to 1% of the valuation of the entire portfolio. Now, the cool thing about this is everything else that's still a part of the limited partner trust over here that we're looking at, you can still manage it. You don't have to worry about paranoia about how you do it. You can actually go plug it into a new asset protection structure. So it allows that separation. You can't do that with an LLC. LLCs aren't designed or constructed to allow you to be able to do this. But if it's set up properly with a limited partnership structure, it can provide you that flexibility. And the reason why it's not a fraudulent transfer is because all of this was done before you got sued. Everything was done prior to the actual lawsuit. So I wanted to share that with you because the other question that people bring up to me as well is they want to know a little bit about taxes and lending. All of this is extremely beneficial for your taxes and lending as well. Notice that each of these properties is a single member LLC. So you will not have to file a tax return for them. So it allows you to be, basically sleek when it comes to not having to pay your CPA an enormous amount of money for every one of those tax filings. Your family trust would be seen as a disregarded entity, so you do not have to file a tax return for it. So, I've got clients with 80 plus properties, and they only have to file these two returns. They file a 1065 partnership tax form here for their limited partnership, and they file a single K1 for their general partner, which, by the way, you want to do. If you want asset protection, you want to file a tax return for the entity that's your backstop, that's protecting you. Always. You don't want it to be a disregarded entity with the IRS when you do that. So I bring this up to say, not everybody needs this, right? But it is important for people that are growing. I tell people it's not just where you're at, but it's also where you're headed. And so sometimes people will come to me and say, Jeff, what if I own properties and I co-host? What if I own properties and I arbitrage? That's fine. One is not exclusive of the other. You can still set up a holding company strategy, whether it be something like this, or whether it be, and I showed the example of whether it's the Wyoming LLC holding company strategy. You could do this as well. You could do either one of these and still set up a separate LLC over here for your holding company, or a separate LLC for your co-hosting. But remember, don't ever intermix what you're doing. Keep them all separate. One does not ever bleed over onto the other. And that's what's critical there. So, and a lot of this works only if you set it up before you get sued. And if you do anything after this, that's when you run into problems. So notice what we talked about. Good, get it out of your personal name into an LLC, right? Separate your ownership from your control. Better, obtain privacy and charging order protection by being able to use a preferential state's holding company strategy to allow you to be able to obtain more asset protection. And then best, if you need post-lawsuit flexibility because a lot of your net worth is in real estate and you don't want to get bogged down if one of them gets sued, then you can use a structure like we talked about right here, which is the Arizona Limited Partnership structure, which allows you to have that post-lawsuit flexibility in addition to that. So I know I threw a ton at you on this, Alex, and there may be something specific that I can also cover for, some of your listeners that are involving arbitrage or co-hosting, or you tell me anything I left out.
So let me ask something in regards to, and you might have already answered this. So take for instance for me, I own a development company, I own a management company, and then I have my properties that I own as well. Some of them are in partnerships, some of them are just JV agreements and whatnot. I mean, different partnerships.
Right.
When you own the operations company, the management company, does this change at all in any way?
So you mean like having having a property management company that's
Managing your properties compared to if someone else was managing them for you?
So that's actually a really good question as it relates to taxes. So one of the things that you do need to be careful of, it's great for asset protection. I'm great with that. People run into this when they have, let's say they get to like 10 properties, a lot of properties. They're like, man, I don't want to have individual bank accounts where I'm having to do individual purchases and 10 credit cards and like,
Yeah,
how do I?
I've fought constant accountants and CPAs on that piece about, I was like, 14 properties, they're spread across 4 or 5 different LLCs. Like I was like, I don't want separate bank accounts for, and then outside of like I practice profit first. So like outside of that, I didn't want then 5-10 other accounts in each one of those LLCs.
Yeah. Well, so the way to simplify it is, and this is a really good question, what you do is you set up a property management company that primarily doesn't make any money. The primary thing that it does is you only feed it enough resources to cover your expenses.
Got it.
And so you can set up your tech stack through it. You can set up everything that you need within that property management business. And then because if you make it make any money, you're actually converting passive income into an active income status. So I've had people do this and they make a huge mistake by actually pulling their distributions from that property management company. Definitely don't want to do that, because if they're at a 37% tax bracket, that's now like almost like W-2 income. That's being pulled out and they're going to be taxed at a higher rate than if they were to just instead move the resources into that property management company just to pay bills. Like just set it up right there where it kind of zeroes out. And then you can still take your distributions from your individual properties and do it at that lower tax rate. Right.
Got it.
So that's where a lot of accountants that I've worked with recommend doing it that way. This is where I talk about it's so important to get an integrated strategic answer. An attorney, most asset protection lawyers would just say, yes, that's a wonderful idea to use the property management company. Even more protection, just set that up and you can tie it into this. But if you don't set it up right and you don't marry the tax piece with the legal piece, you can end up making an enormous mistake and costing you thousands of dollars.
Right? Yeah, absolutely.
So great question.
What do you think of, because I've heard two separate, like multiple things on it, the real estate professional status qualifying for it. How does that work in terms of this whole structure? Because I get that, I got that a lot this year when we did that big raise on the treehouse community, was we were given the entire tax benefit to our limited partners, without confusing the listeners too much. And the only way for them to even qualify for like the cost segregation analysis and all the tax benefits was at the highest level to qualify, was to qualify as a real estate professional. Does this structure sort of mess with that a little bit? Or it's fine if it does, but it's just, where does that fit in?
So let me walk you through that. Whether you were to do it, let's first talk about the Arizona limited partnership structure. This is designed specifically for all of the tax benefits of what you obtain to roll up to your personal return, right?
Awesome.
If you were to use an irrevocable trust right here, as opposed to a revocable trust, you could lose some of those benefits. Okay.
Yeah.
So for the most part, I always remind people, this is all from an STR perspective, or just a, quite frankly, whether you're a real estate professional, material participation, however you want to call it, I kind of call it the STR tax loophole in terms of what you're able to do to obtain that benefit. This does not in any way negatively affect it, because that's why I'm always telling people, whoever you work with for asset protection, make sure they're willing to have that meeting with your accountant, and make sure your accountant, if you talk about cost segregation and bonus depreciation and they don't know what you're talking about, you better run for the hills, because you've got to make sure that these two pieces are integrated. I currently have hundreds of clients that are using this structure, as well as the Wyoming LLC structure here that we showed you earlier. And both of those are integrated to where you're able to be able to still maintain that bonus depreciation. And I'm right there with you. You maintain the status. It's great to be a real estate professional or meet the material participation rules, but you have to make sure that you're actually able to do the cost segregation and pull it over onto your return, so that you're able to get that big tax refund back off your W-2.
Yeah, I know, like, people are like frantic here for the next like 3 years, because that's slowly going away.
Yeah. Right. We're at what, 80% this year, and then 60 next
60,
year. Right.
40,
We're
20,
it's
done.
Right. It's sunsetting its way down.
Yeah.
There was one more thing I was going to share with you as well that I didn't get into a second ago. Okay.
Yeah.
So I have, and some of your listeners may run into this situation too. This is a new concept that I didn't talk about earlier, known as an anonymity land trust down here at the bottom. Okay. And I didn't talk about this much at the conference either, but here's the thing to be aware of. Many short-term rental owners, they buy their first property. Maybe you're doing arbitrage or co-hosting right now, and you're about to try to go out there and find you a good deal. You need to be very aware of the consequences of whether you're purchasing a conventional loan or a commercial loan, and whether you're going to close in an LLC, or if you're going to wait and decide you're going to move it over into an LLC post-closing. Okay. And what do I mean by that? 2/3 of all states have what's called a real estate transfer tax.
Yeah.
Okay. So if you try to move assets over post-closing in a conventional mortgage into an LLC, states like Tennessee with the fonts tax, Florida with the doc stamps fee, these states will come and just hammer you, right? And here's the solution to that. There's really three main issues: real estate transfer taxes, the due on sale clause, which I'm not that concerned about.
I've never, for anyone who knows, I've never heard of any bank exercising that. Yeah. Personally.
And it almost never happens, particularly because Fannie and Freddie and FHA loans, they don't call the notes due, and that's the bulk of conventional mortgages. Yeah. So it's not a concern. The third issue, though, is a bigger concern, and that is if you ever want to refi, which right now, everybody buying, you are going to want to refinance. I mean, it's 100% certain. So if you are in a real estate transfer tax state, though, which is 2/3 of the states, what do you think if you move a conventional mortgage? Let's talk about this for a second. If you have a conventional loan and you move it into an LLC, can you refinance a conventional loan in an LLC? No, you cannot. It's not. You're not allowed to do it. Underwriting won't do it because it's a conventional loan. It's a residential mortgage. And when they find out it's in an LLC, guess what they're going to make you do? Pull it out. And what happens when you pull it out? You get taxed. It's a transfer. And then what happens after you refi and you want to put it back in? You get taxed again. You'll get double taxed on a refi. So the solution to that is what we call a land trust. Okay. A land trust is, this is kind of represented down here by this little blue box. A land trust is a simple grantor trust you move property into. Okay. And it's real simple. Here's what happens. You're the beneficiary on the trust. Your attorney or a third party can be your trustee. Now, a trust is never in public record. No one ever sees it. The only time they ever know anything about it, anyone ever knows about it, is when you move property into it. On the deed, it's going to list the trust and it's going to list the trustee. Well, we would be the nominee trustee. Attorneys many times are the nominee trustee, that as soon as they transfer title, they resign, you become the successor trustee. So in public record, no one knows you own it. So it creates anonymity. But the second benefit is there is a legal, and I know I'm getting into the weeds here, but follow me. There's a payoff.
Yeah.
The benefit is you can do what's called an assignment of beneficial interest. You can assign what is the beneficial interest, anything worth suing, anything that has value in your property, right? You can now assign that into an LLC. So now you obtain asset protection. But because the property remains in the trust, you don't have to pay the transfer tax because there was never a transfer. Okay. So you avoid the transfer tax. And under the 1982 Garn State Germain Act, they cannot call your note due. So you don't have to worry about the due on sale clause. If you do that through a land trust, it's prohibited. They cannot even do it. Then the third thing is when you want to refinance, what can you do? Remember, we said a second ago that you can assign your beneficial interest into the LLC. Well, now you can reassign it back down into the land trust, change the language to a living trust, hand that living trust over to your lender. It'll be approved. You can refi it. Then you change the land trust. It's just changing language back to a living trust, reassign it back into the LLC, totally anonymous. Avoid the transfer taxes, avoid problems with your lenders, all of that. So I spend a lot of time talking about this because people don't understand. If you're doing a commercial loan, it makes no sense to avoid closing in an LLC. You should absolutely close in an LLC. If you're taking out a commercial loan, the number of people I see just closing in their name, I'm like, why? You can avoid all of these consequences if you just close in an LLC right out of the gate. So this is an important aspect to know, that there can be some barriers just getting it out of your personal name. No one, I had a guy call me, $30,000. He had a 3-point-something million beach house. He was going to be looking like a $30,000 transfer tax. I was like, whoa. I mean, no one wants to pay that. So you want to make sure and use these techniques like land trust to help you avoid those consequences.
That's huge.
Yeah. I mean, I joke about it. The land trust is like the utility knife, like a Swiss Army knife for real estate. There are so many things that you can do to get assets out of your personal name. You can create anonymity. It's good for fix and flips. Flippers use them a lot as well. There's ways that you can use that in order to help avoid some of those consequences from the government and just anonymity's sake. So I didn't want to miss that because I know some people might be saying, if these assets are in my personal name, how do I even begin? These are the kind of things to be aware of. And really, it starts with working with a lawyer that knows those obstacles in every state. Texas, no transfer tax. You don't have to worry about it. Florida, big, doc stamps fee. It can hit you. Tennessee. So every one of these states are areas you need to be somewhat aware of before you hop in to your deal so that you don't make those mistakes.
Yeah, absolutely.
So. But sorry, I know I went completely legal on you there for a minute. I had to try to.
Oh, you're fine. You're the attorney. That's the whole reason why we're doing it. Yeah.
Anyway, but that's the main point here, is that at the end of the day, this stuff doesn't have to be super overwhelming and complicated. But of course, like I mentioned, it has to be done before a lawsuit. And, I think the most important thing is that you're certainly consulting with an attorney. You can do a lot of this if you understand the concept. You need to know enough about it to make sure that the attorney and the CPA you're dealing with know what they're talking about and that they know what they are doing. But I see these steps as an investment in growth that won't hold you back from when you continue to move towards your next investments.
Yeah, absolutely. And it's just one of those things, that's the whole reason why we decided to connect, was for a lot of the students, including me, I'm learning stuff that I didn't know here. You don't know what you don't know. Yeah. And like I say, with other stuff, is dig your well before you need it. That's practically what you said earlier. The stuff's incredibly important. Even if you have one property, great. But like you said, once you get 3, 5, 10, the amount of guests that are coming through your properties, we have 14, Friday check-in day, Friday, Sunday checkout day. We have tons of guests. Not because when you have 14 properties, that doesn't mean 14 guests. That means that could be up to 40, 50 guests
right
in one check-in. So that's 40, 50 different scenarios that could happen at your property.
Yeah. Absolutely. 100%. Yeah. And that's, I've got a property that sleeps 25, it's an 8-bedroom, and it's got all these high risk amenities. It's if things are not set up properly and you don't have this in place, honestly, it's a matter of statistics. It's not a matter of if, it's a matter of when something will come up where someone will try to, plus you don't know what bad actors you're dealing with.
Right.
Sometimes
absolutely.
you deal with, right.
So for anyone who wants to connect with you, Jeff, you're offering free consults for anyone that is interested in just asset protection, everything that we talked about today.
Yeah, listen, all of your listeners now, here's what we will do. And a lot of attorneys charge for this, but I'm not a believer in asking people to invest in things they don't understand. So
Yeah.
what we do is take an actual, we ask people to fill out a questionnaire just to give us a
Yep.
basic understanding of where you're at. And we put together these visuals you saw here today. We put those together for you custom. It's specific to exactly your situation. We walk you through it, and then we provide you an action plan, and then we let you actually take that home. That's something you get to keep and hold on to. And some people are ready to do this now and they understand the need for it. Other people are saying, hey, this is on my agenda for 2024 or into the future, and I need to know what I need to do when the time is right. So we do provide that at no cost.
Awesome. Awesome. And then we'll link that below this video somewhere. Is there anything you want to leave the students with, or I say students, the listeners with? Yeah.
Well, here's what I want to leave you with is, first of all, you've made the first step in investing in yourself by watching all of this. I know when you look at legal stuff, you're like, people have a tendency to want to zone out on it, but these are the type of things that ignoring it won't make it better. So I applaud you for actually spending the time and listening to what we're talking about. The second thing is have a plan of action. Really, I think it's Alex Jarbo that once said that the definition of actual being smart and between learning and actually having a high IQ is people with high IQs can see the need for something, but if they don't take action on it, it doesn't mean they ever learned it. So one of the things I'm a big believer in is being an action taker, even if it's working with doing some of this stuff, setting it up with another local attorney, doing some action plan of what you're going to do, whatever it takes here. You don't want to be that person trying to call and find out what to do after someone's trying to threaten you with a lawsuit. So I think education can help move people to action. So that would be my kind of call to everybody as they watch this.
Awesome, guys. Yeah, like I said, if you guys are interested in that, we're going to link it below. It's just going to be strlawguys.com and then the / after it. But if outside of that, and any other social media handles or anything that you want to plug in terms of LinkedIn, Instagram, or are you mainly just on your website?
Yeah, if you go to the Jeff Hampton, if you type in Jeff Hampton STR, it's Jeff Hampton STR for my YouTube channel. Same thing for my Instagram as well as TikTok. Do any search there and you do for asset protection, you're going to find me. And I encourage you, I put out a lot of free content to help educate people. And I have additional content specific to those in arbitrage and co-hosting and regulations. So I just love being able to share this stuff for people because, quite frankly, there's a need for this and people need to be aware of it before they kind of step into these potholes.
Awesome. Yeah, absolutely. Awesome. Thanks, Jeff. So if anyone's interested, links below, and I will see everyone on the next podcast. Thanks.
Thanks, Alex.